Hello and welcome to this video on Article 8, which is the right to respect for private and family life. So I'm just going to start off with this flowchart here. This is the flowchart you would go through if you were to have a problem question on this, a scenario question. So the first thing you'd have a look at is whether there is actually an interference by the state with family life, private life, home or correspondence. So we're going to have a look at the definitions of those with some case law. If there is some interference, you then look at whether the interference can be justified. So you have a look at whether it is in accordance with the law, whether it meets a legitimate aim, and whether it is necessary in a democratic society. In order to have a look at whether it is necessary, you look at the margin of appreciation. So is there a wide or a narrow margin of appreciation? And given the margin of appreciation, is it proportionate for the aim they are trying to achieve? So let's have a quick overview of Article 8. So Article 8 is a qualified right. This means that a state can justify an interference under certain conditions. It is normally that the court finds an interference and then it is for the court to decide whether that interference was justified, looking at whether it was necessary, whether it was in accordance with the law, and whether it was for a legitimate aim. So the principles of proportionality and margin of appreciation are very important in this decision-making process. So I've got the definitions here again. I have gone into a bit more detail with these on the European Court of Human Rights video. So proportionality is a tool used by the European courts to find the balance between the rights of individual and the community when deciding upon qualified rights. So it looks at whether it's proportionate at meeting the aim. And then the margin of appreciation is a doctrine that considers the amount of discretion given to the state by the European Court of Human Rights when adjudicating or deciding on alleged violations of qualified rights. Once again, more detail on those is in the European Court of Human Rights video. So the reason that Article 8 is a qualified right is that it often clashes with the rights of others, especially an individual's rights to freedom of expression under Article 10 of the Convention. You've had a look at these cases before. We've had a look at Douglas and Hello, for example. It is often that the right to private life deal with the media wishing to print stories about individuals and their private lives. Silence in the media then goes against the right to freedom of expression. So it's important that the court must balance these two rights, and it looks at the public interest as well. So going back to Douglas and Hello, we had a look at this under the guise of indirect horizontal effect, because it was the court's job, it was bound by the Human Rights Act to ensure a balance is struck between an individual's right to privacy and an individual's freedom of expression. So technically, the right to a private life is a negative right. A negative right, in other words, means that it is not the job of the state to interfere with it. They're meant to step back and not interfere with the right to a private life. However, it has been interpreted in such a way to include positive obligations. In other words, it means that the state must take action to ensure that the right is protected. So the use of the word respect in Article 8 has been interpreted under the living instrument principle to expand the protection of this article into areas which may not have been thought about when it was first created in 1950. So a case that shows that there is a possible positive obligation on the state, or it turns it into a positive right, is X and Y and the Netherlands. So in this case, the applicant was a young woman who was sexually assaulted by a man. Because she was mentally disabled, she was not able to give evidence, and therefore no charges were brought against her aggressor. So in this case, it was held that the state was under a positive obligation to prevent harm which may interfere with the Article 8 right of the applicant. So in this case, under the Dutch law, there was no framework to provide adequate safeguards to those people who were unable to present their case because of their disability, and it didn't give the option of allowing someone else to bring the case on the girl's behalf. Therefore, there was a violation of Article 8. This positive right extends to the state being forced to recognise an individual's right to change their sex, as in Goodwin and the UK. So we had a look at Goodwin once again when we were looking at the living instrument principle in the European Court of Human Rights video. and that led to the Gender Recognition Act 2004. Just to recap, so we've looked at just an overview of Article 8 at the moment. So does the state action interfere with private life, family life, home or correspondence? So we're going to have a look at the definitions of these. So private life has been given a wide meaning by the European Court of Human Rights. As I said before, it's often that an interference is found, and then the court has a look at whether that interference is justified. So there were a few cases here which had a look at private life. So in Peck and the UK in 2003, the court noted that private life is not capable of an exhaustive definition. In Pretty and the UK, so Diane Pretty, the court noted that the very essence of the convention is respect for human dignity and human freedom, and it included quality of life issues under private life. And in Essen Marper and the UK, the court found that private life encompasses multiple aspects of a person's physical and social identity. So this case was to do with their fingerprints being kept on a DNA database. Family life then, lots of cases, you don't need to know them all, but family life encompasses children and grandchildren, adoptive relations, family relationships after divorce. It includes close family ties dependent on circumstances, cohabiting heterosexual couples, foster relationships, homosexual relationships as well. This reflects the live-in instrument principle. We look at 2010. Obviously, people are starting to be a lot more liberal at that point. Home definition, once again, there's a lot of case law around this. You don't need to know them all. We've got that the meaning of home includes a person's existing home, but does not guarantee a right to a home. However, there may be limited circumstances where Article 8 may infringe when the failure to provide alternative accommodation to an applicant with a severe disability, the prevention, to allow someone to return to their home also fell under Article 8. Homes can also cover houses that have not been lived in continuously. Land occupied by caravans can constitute a home, and even a business premises could be seen as a home. Okay, so this key case here that expands the definition massively. Correspondence then, very straightforward. Golder and UK held that it was even correspondence that was for those held in state custody, so in prison. Correspondence is all forms of communication, including letters, telephone, fax, and emails. If you have a look at interception of communications, obviously that would deal with interfering with their rights to private correspondence. So you've had a very quick look at the definitions of family life, private life, home, and correspondence. Once again, you don't need to know all the cases. The highlighted ones are kind of your key ones for it. So say you've got a problem question and you've noted that there has been an interference. We then will have a look at whether it's justified. So if it is found that there is an interference with Article 8, as it normally is, the state has to justify the interference with that right. So it must be in accordance with the law, so there must be some legal basis for the action. It must meet a legitimate aim, and it must be necessary in a democratic society. So if you had a look at Malone and UK, for example, the interference with the Article 8 right of Malone was not in accordance with the law. Okay, so any act that interferes with Article 8 must be in accordance with the law. This means there must be a legal basis for the action. And this legal basis has to be clear, precise, and predictable. So, for example, in Copland and the UK, it was held that surveillance of a staff member's college email account was not justified, as there was no clear basis in law that allowed the college to monitor emails. So, like I said before, this links to the Investigatory Powers Act, state surveillance, interception of communications. Malone, once again, Malone you would have had a look at in a bit more detail in state surveillance or interception of communication. But there was no law in place that allowed this interception that took place, and therefore the Interception of Communication Act 1985 was passed. If you need to read it, you can always pause this video. So it must meet a legitimate aim, and Article 8, subsection 2 sets out these aims. It is normally found that the state does have a legitimate aim because they are quite broad. So things like national security, public safety, for the economic well-being of the country, prevention of disorder or crime, protection of health and morals, protection of the rights and freedoms of others. So very, very wide. And it does mean, though, that the aim argued may influence the margin of appreciation and then the proportionality of the measure. It must also be necessary in a democratic society. To decide this, the courts use the concept of proportionality and margin of appreciation. Okay, one final slide then, key case law for evaluation. We've had a look at these in other topics. So, for example, you've got Gillen and Quinton and the UK, which we looked at police powers, stop and search. You've got Dudgeon in the UK, covered that when we looked at the European Convention and the European Court. Goodwin in the UK, once again, European Convention, European Court. Same with Pretty in the UK. Then you've got Douglas and Hello, which is what we covered in the Human Rights Act. And S and Marper, which we looked at under police powers. So you can use these cases and what was held in the case to argue whether the Article 8 right is protected under UK law or under the European Convention on Human Rights in general. That's it from me. If you've got any questions, let me know. Thank you.